I've been really excited about this event, so I'm so glad we got such a good crowd. What better way to make the point that women deserve equal opportunity to jobs and pay than to co-sponsor this event with the women lawyers of Santa Cruz County and have two of their members tell the story of Lilly Ledbetter and her fight for equal pay. I know it's going to be great. Interesting story. Representing the women lawyers of Santa Cruz County this evening are attorneys Ashley Wheelock and Syda Kosofsky Cogliati, but she just goes by Syda Cogliati. Ashley attended UC Berkeley for her BA and earned her Doctor of Law degree from George Washington University Law School. She practices civil litigation in the areas of personal injury, employment, neighborhood disputes, and contract law. Syda attended UC Santa Cruz for her BA and earned her Doctor of Law degree from UC Hastings College of Law. Syda specializes in appellate law, which I had to look up. That is law involving the appeal of cases to higher courts, right? Both Ashley and Syda are married and both have 2 children, 2 girls for Ashley and a girl and a boy for Syda. So of course, having girls, this is very much of interest to them. So let's give Syda and Ashley a big hand and let them get started.
Thank you everyone for being here today and good evening. So Syda, why are we even talking about equal pay in 2016?
That is a really good question, Ashley. It's 2016, so it's an election year. Let's go to the campaign trail where we'll actually hear a similar question being asked. Hopefully we'll hear it.
Let's give it a pause. Can we turn up the volume on this? Roger?
And my mother over there is complaining that she does not get much more money than my father. My mother's an engineer. My mother's an engineer. I'm a teacher. My father's the engineer. And I think that my mother is working more harder than my... I don't want to get I think my mother is working more harder than my father, and she deserves to have more money. Like, get more money than my father. Because she's taking care of children, and I just don't think it's fair.
Oh, that is really so sweet.
So this is Lilly Ledbetter Equal Pay Day. Doesn't that mean, Syda, that we at least have come a long way towards equal pay for women?
Well, let's back up and talk about Lilly Ledbetter, the woman whose name has become synonymous with women's fight for equal pay.
Yeah, please tell us about Lilly Ledbetter.
So Lilly Ledbetter was the plaintiff in a federal lawsuit against her former employer, Goodyear Tire. In her lawsuit, Lilly Ledbetter claimed she'd been discriminated against because she was a woman during her employment at Goodyear. She claimed that because she was a woman, she had received poorer performance evaluations and lower pay than her male colleagues.
What happened while Lilly was working at Goodyear?
Well, Lilly started working at a Goodyear tire plant in Alabama in 1979. She was a salaried worker, and each year her performance was evaluated, always by a male supervisor, and she was often ranked at or near the bottom, which affected her pay. By 1997, she was the lowest paid worker in her position, and the next year, 1998, she was denied a raise and pressured into a different position.
At that point, didn't she just get fed up?
Yep. Lilly Ledbetter filed a complaint with the Equal Employment Opportunity Commission, the EEOC for short. The EEOC is a federal agency that enforces laws that make it illegal to discriminate against an employee because of the person's race, color, religion, sex, national origin, age, disability, or genetic information. So after filing her complaint with the EEOC, Lilly Ledbetter then filed her federal lawsuit.
What laws or law did she file under?
Lilly Ledbetter sued Goodyear under both Title VII of the Civil Rights Act of 1964 and under the Equal Pay Act of 1963. But interestingly, her claim under the Equal Pay Act was thrown out on summary judgment.
The Equal Pay Act sounds like something would be perfect for her to sue under. Why didn't she get to pursue her claim under the Equal Pay Act?
Well, the Equal Pay Act says an employer cannot pay employees of one sex less than employees of the opposite sex for equal work. However, the Equal Pay Act does allow some exceptions. It allows pay disparity based on seniority and merit. Goodyear was able to argue successfully that the pay decisions were all based on merit. Apparently, it didn't matter if the merit decisions were discriminatory.
That doesn't sound like a very effective law.
That's true, and even when President John F. Kennedy signed the Equal Pay Act, he described it as only a first step, and he emphasized that, quote, much work remains to be done to achieve full equality of economic opportunity. But remember, before the Equal Pay Act was enacted in 1963, lower pay for women was accepted and widespread.
Oh, right. Our society was operating on the paternalistic assumption that women's earnings were not nearly as important to the household income as a man's, and that women should be supported by their fathers and husbands.
Yeah, for a long time it was generally accepted that women just didn't need to be paid as much as men.
So let's get back to Lilly Ledbetter. You said that her claim went forward under the Civil Rights Act only. But didn't the Civil Rights Act just bar discrimination based on race?
The Civil Rights Act of 1964 actually outlawed discrimination based on race, color, religion, sex, and national origin.
So what happened in the Lilly Ledbetter lawsuit?
Well, in fact, Lilly Ledbetter won initially. Her case went to trial, and the jury found that Goodyear had paid her less money because she was a woman. Lilly Ledbetter was awarded back pay, compensation for mental anguish, and punitive damages. It was over $3 million.
Wow, that's awesome. But I know and you know, and now everybody else will know, that that wasn't the end of it. Did Goodyear appeal from this verdict?
Yes. On appeal, Goodyear argued that Lilly Ledbetter had brought her lawsuit too late. You see, Lilly Ledbetter had to file her EEOC claim within 180 days after the discriminatory employment action in order to bring a lawsuit in federal court based on that same discriminatory action.
But didn't Lilly Ledbetter file an EEOC claim right after she was denied a raise?
Yes, her claim was timely filed as to that, the very last discriminatory employment decision about her pay. However, the jury at trial had been allowed to consider whether Lilly Ledbetter had been discriminated against every time she went through the annual review, that is, ever since she began working for Goodyear in 1979, which was almost 30 years before she filed with the EEOC. So in the appeal, Goodyear argued that Lilly Ledbetter should only have been permitted to challenge that very last salary decision because that was the only one that fell within the 180-day window.
What? So even though Lilly Ledbetter filed her EEOC claim right after she was denied another raise, she could not claim that she had been discriminated against each time her salary was assessed. She could only claim that one of those decisions in all 30 years was discriminatory.
That's exactly right. And the 11th Circuit Court of Appeals agreed with Goodyear.
But Lilly Ledbetter appealed to the United States Supreme Court, right?
Yes, that is right. And Ashley, why don't you tell me what happened in the United States Supreme Court?
The question was still whether Lilly's lawsuit was timely as to the entire series of employment reviews and salary decisions that led to her unequal pay. There was a split of opinion in the federal courts as to whether such claims involve discrete acts of discrimination or whether the courts can consider the combined effect of a series of discriminatory pay decisions.
So the United States Supreme Court agreed with Lilly Ledbetter, right? I mean, they said the jury correctly considered the entire series of discriminatory pay decisions.
No, even though this is Lilly Ledbetter Day, that's not why it is. In 2007, the United States Supreme Court rendered its decision. It found in a 5-4 decision in favor of Goodyear Tire.
Wow, that was close. Who wrote the majority decision and what other justices signed it?
I kind of jumped ahead and put this slide up, but you that decided it. Justice Samuel Alito wrote the majority opinion, joined by Chief Justice John Roberts, the late Justice Antonin Scalia, Justice Anthony Kennedy, and Justice Clarence Thomas.
All men? What did these 5 men say?
The majority opinion upheld the 11th Circuit's decision, finding that Lilly's claims were almost entirely time-barred. The majority noted that Lilly had not even claimed her final pay decision was motivated by discrimination, but that it was a result of prior acts of discrimination. Thus, the majority strictly construed the 180-day statute of limitations.
Wow. Let's back up for a minute. This is an election year, and there's a lot of political arguments right now about who should fill the current United States Supreme Court vacancy. So let's talk about how these 5 men who rolled against Lilly Ledbetter got on the court.
Justice Alito and Chief Justice John Roberts were appointed by President George W. Bush. Justice Scalia and Kennedy were appointed by President Reagan, and Justice Thomas was appointed by the first President George Bush.
Interesting. All right, well, let's talk about the 4 justices who dissented. Tell us about the dissent, Ashley. Who wrote it and who signed it?
The dissent was written by the justice most famous for her advocacy on behalf of women's rights. Yes, hers, Ruth Bader Ginsburg. Who has actually become something of a cultural phenomenon. You may know her as the notorious RBG, which is a play on a rap song, or you may have heard the slogan, "Can't spell truth without Ruth." Or you may have heard that there was a big movement to have a Ben & Jerry's ice cream flavor named after her. Unfortunately, that never happened, but there is a picture. We're still hoping. I mean, ginger is a favorite flavor of mine.
I love it. Well, what other justices joined Justice Ginsburg's dissent in the Lilly Ledbetter case?
Justice Ginsburg's dissent was joined by Justice John Paul Stevens, David Souter, and Stephen Breyer.
Wow, so Justice Ginsburg was the only woman on the Supreme Court at the time. What did her dissent say?
Justice Ginsburg and the other dissenters would have allowed Lilly Ledbetter's lawsuit to include all of the employment decisions that resulted in her being paid less than doing comparable work by a man, all 30 years. The dissent recognized that pay discrimination results from small, incremental decisions, each of which might not be enough in and of itself for an employee to bring an action right away. Justice Ginsburg repeatedly referenced the realities and the real-world characteristics of cases like Lilly Ledbetter's.
Sounds like Justice Ginsburg really gets it. Can you tell us how she and the other 3 dissenting justices got on the U.S. Supreme Court?
Absolutely. Justice Ginsburg and Justice Breyer were both appointed by President Bill Clinton. Justice Stevens was appointed by President Gerald Ford, and Justice Souter was appointed by President George Bush, the first President George Bush.
All right. Well, and how did Lilly Ledbetter feel about how her case ended at the U.S. Supreme Court?
Well, she did go from winning $3 million to losing, but let's hear it from her.
I was so excited, so excited. I had 6 different interviews and was accepted for the job and was thrilled beyond belief. I could not believe it. We had a tremendous Christmas. Phil bought me a balloon that was a blimp, a Goodyear blimp, and it was blown up. And we had such a party and such a celebration. I put in the time, I worked hard. There was nothing, no job that I would not do. I could stand up with any male that was there. I just felt like somebody had let the air out of my balloon. I was just flat on the floor to know how much difference there was in my pay versus theirs. A jury of 7 people, federal court, awarded me $3.8 million. I won the case. Went all the way to the Supreme Court. They heard the case in November of 2006, but they voted me down. They voted 5-4. I lost by 1 vote. It was not fair. It wasn't even close to being fair. We must go to Congress, the House, and the Senate to prevent this from happening in the future to other females and minorities. I have a granddaughter who will come along in the workforce in about 20 years, and I hope that the law is changed and things will be much easier for her.
Whew. Sounds like Lilly Ledbetter really wanted to keep fighting for a change in the law.
Yes, and in fact, Justice Ginsburg's dissent ended with a call to Congress, saying that the ball was in Congress's court, and specifying that Congress had the power to amend Title VII to correct the majority's reading of the statute. Syda, why don't you tell us why, since we know that we're sitting here on Lilly Ledbetter Equal Pay Day, and she lost her case, that we're celebrating it as such?
Oh, gladly. In 2009, the federal law, that is Title VII of the Civil Rights Act of 1964, was amended through the enactment of the Lilly Ledbetter Fair Pay Act.
What wonderful senator or congressman introduced the bill to make that happen?
Senator Barbara Mikulski, Democrat of Maryland. She was the main sponsor, but there were 52 co-sponsors, and those included both then Senator Hillary Clinton and Senator Bernie Sanders. And President Obama signed the bill into law on January 29th, 2009.
January 29th, 2009. Go ahead, Tom. Sorry. Yes, very good thing. But that date kind of sounds familiar. Wasn't that the same day that President Obama was inaugurated?
Yeah, in fact, it was the Lilly Ledbetter Fair Pay Act was the very first bill that President Obama signed as president. And in signing the bill, he stated that with this new law, we are upholding one of this nation's first principles, that we are all created equal and each deserve a chance to pursue our own version of happiness.
What did the Lilly Ledbetter Fair Pay Act say exactly?
Well, here's what the law now provides. Pay discrimination claims accrue whenever an employee receives a discriminatory paycheck, as well as when a discriminatory pay decision or practice is adopted, when a person becomes subject to the decision or practice, or when a person is otherwise affected by the decision or practice. The new law states that the 180-day statute of limitations for filing an equal pay lawsuit resets with each new paycheck affected by that discrimination.
So if the law had been written that way when Lilly sued, her case would have not been thrown out of appeal.
That's right. Lilly Ledbetter's entire pay and employment history would have been relevant to show that her pay was discriminatory.
But unfortunately, that still means that Lilly Ledbetter herself, who sued in 1999, long before this law, never received restitution from Goodyear.
That is true. But Lilly Ledbetter has indicated she feels vindicated. She said, quote, "I'll be happy if the last thing they say about me after I die is that I made a difference."
And I think she certainly made a difference.
She did make a difference. But although the Lilly Ledbetter Fair Pay Act has begun helping women achieve some equality and protection in the workplace, our fight for equal pay is far from over. Ashley, what are some of the ways in which women are still discriminated against in the workplace, resulting in unequal pay?
Well, I think we should start with some statistics, because that'll help with this discussion. First, I'm going to show you a chart that has data from 1963, and you can see that some progress has been made, but the National Women's Law Center shows that women today are paid, on average, only 77 cents for every dollar paid to men. And the gap is even worse for women of color. African American women earn only 64 cents to the dollar of men, and Latina women only earn 55 cents for each dollar earned by their male counterparts.
Whew. How about for well-educated women? For example, lawyers like us. Haven't we achieved equal pay or close to it?
Nope, I wish it were true. Even with education, there is a substantial wage gap, and I have another chart here to show you. You can see that for women who started high school but not finished, there's still a 31% wage gap. For women who finished high school or had a GED, 26% wage gap. Some college but no degree, 27% wage gap. An associate's degree, 23% wage gap. Bachelor's degree, 26% wage gap. Master's degree, 27% wage gap. Professional degree, 32% wage gap. And doctorate degree, 23% wage gap. It's across the board. And the wage gap is even worse for older women. You can check it out. It's the younger age group actually has the smallest wage gap of 8%, and women 65 and older are looking at a 30% wage gap still today.
What are some of the reasons? Why does this wage gap persist?
One problem is that there are a lot of higher paying types of jobs that are predominantly held by men. Here's another chart also from the National Women's Law Center. It has a list of some of the highest paying jobs, the top 25 or so. And you can see that from the percentage of women in those professions, like aircraft pilots and fighter engineers, only 4% of those jobs are held by women. or computer and information systems managers. Only 27% of those jobs are held by women. So that is going to definitely affect how high women are paid.
Well, what are some of the barriers that women face to entering higher paid jobs?
Although we're doing better, unfortunately, women are still actively discouraged from pursuing some of these jobs or are subject to harassment on the job.
Well, are there any efforts underway to address these problems?
There are some efforts underway. There are 2 proposed federal laws. One is called the Paycheck Fairness Act, and the other is called the Equal Employment Opportunity Restoration Act.
Great. So let's first talk about the Paycheck Fairness Act. Since I'm a voter, I'd like to know who introduced this equal pay law.
Can you guess? We saw her before. The current version was introduced by Senator Barbara McCluskey of Maryland.
The same Barbara McCluskey who was the main sponsor of the Lilly Ledbetter Fair Pay Act. Tell us about her, Ashley. She sounds pretty awesome.
And she is. Barbara McCluskey is 79 years old. She's under 5 feet tall, but she is quite a powerhouse. She was first elected to the House of Representatives in 1976 and elected as a senator in 1986. Unfortunately, she's retiring this year after 40 years in Congress.
Oh, that's too bad. We will miss her.
Yeah, we're going to miss her, but I have a feeling she's going to go on to bigger and better things. When she announced her retirement, she said that she decided against seeking a 6th term in office because she wanted to focus the next 2 years on helping her constituents, rather than spending the time and energy on another political campaign. She asked, do I spend my time raising money, or do I spend my time raising hell?
I love it. So what would the Paycheck Fairness Act do exactly?
The Paycheck Fairness Act would punish employers for retaliating against workers who share wage information, put the burden on employers to justify paying a woman less than a man, and allow workers to sue for punitive damages for wage discrimination. The bill would also fund programs to help train women to better negotiate their wages.
Is there any chance that the Paycheck Fairness Act will pass soon?
Well, it was originally introduced in 1997, nearly 20 years ago. It's been reintroduced numerous times, each time to no avail. Every time it's come up, the Republicans have filibustered it to prevent the bill from even coming up for debate.
Wow. All right, well, how about the other one, the Equal Employment Opportunity Restoration Act? What would that law do?
One of the main purposes of the Equal Employment Opportunity Restoration Act is to allow an employee to bring a group action for sex discrimination on her own behalf and for those other affected female employees.
Why do we need a law that lets one female employee bring in a lawsuit on behalf of others?
This proposed law is actually in response to another United States Supreme Court case, Dukes versus Walmart. In that case, several female Walmart employees sought to bring a class action against Walmart for pay discrimination on behalf of all the female employees. In Dukes versus Walmart, the court did not let the class action go forward because the female plaintiffs could not show that all of Walmart's female employees had a common claim that was capable of class-wide resolution.
Wow, what were the Dukes plaintiffs arguing? How did Walmart discriminate against them?
The 3 named plaintiffs in the lawsuit claimed that their local manager's discretion over pay and promotions was exercised disproportionately in favor of men, leading to an unlawful, disparate impact on female employees. They also claimed that Walmart was aware of this effect, yet it refused to do anything about it.
So the women were claiming that Walmart's corporate policies had a discriminatory effect on their pay because they allowed this discretion to be made.
That's correct, but in another 5-4 decision, the Supreme Court majority disagreed with the female employees. The majority said that the female employees had only shown that they were separately discriminated against, not that their claims were similar enough to go forward as a class action. So the court said that the lead plaintiffs could not sue on behalf of all female Walmart employees.
Well, let's talk about this Supreme Court decision. Was it all men in the majority again?
You guessed it. The majority opinion was written by the late Justice Scalia. The 4 other justices in the majority were Justice Roberts, Justice Kennedy, Justice Alito, and Justice Thomas.
Okay, 5-4, so there was a dissent again. Did Justice Ginsburg write it again? And what other justices were in the dissent?
She did write it again. Justice Ginsburg wrote the dissenting opinion, which was signed by the 2 other female justices who had come on board, Justice Sonia Sotomayor and Justice Elena Kagan, and also by Justice Breyer.
So the dissent would have let the class action lawsuit proceed against Walmart, right?
Yes, the dissent thought the female plaintiffs had shown a common question of pay discrimination.
So the Equal Employment Opportunity Restoration Act has been proposed as a fix for the Dukes v. Walmart decision. Does that mean it would allow more equal pay claims to go forward as class actions?
Exactly that. And employees would be able to challenge an employer's practice of leaving personnel decisions to the discretion of supervisors.
What are some of the benefits of a group or class action as opposed to an individual lawsuit?
Actually, there are a lot. Group actions reduce the likelihood of retaliation against an individual employee. Also, with a class action, lawyers are more likely to take the case without charging initial fees to an individual plaintiff, since they can recover on behalf of a group. And when the group action is successful, the benefits are greater. Group actions result in employer-wide solutions to employer-wide problems.
Well, I sure hope those laws eventually pass.
Me too, but it hasn't been all negative. Let's talk about some successes. Syda, I think the United States Supreme Court may have issued a recent decision actually in favor of women in the workplace.
Yes, they actually did. That's the case of Peggy Young versus the United Parcel Service, or UPS. Peggy Young was a UPS driver who became pregnant. Young's doctor told her that she should not lift more than 20 pounds during the first half of her pregnancy and no more than 10 pounds during the second half of her pregnancy.
How much lifting do UPS drivers have to do?
UPS required drivers to lift up to 70 pounds. So, UPS told Young she could not work while the restriction was in effect. Young ended up staying home without pay because UPS refused to accommodate her lifting restriction.
And what kind of accommodations was Peggy Young seeking, and why wouldn't UPS give them to her?
So Peggy Young wanted to be assisted by coworkers or given a temporary alternative work assignment. Young alleged that other UPS drivers were accommodated when they had lifting restrictions caused by conditions other than pregnancy. UPS had accommodated drivers who, for instance, were injured on the job, or drivers who were considered disabled under the Americans with Disabilities Act. But UPS said that since Young didn't fall with any of those groups, it had not discriminated against her by failing to accommodate her.
Wait, so the only employees that UPS did not accommodate were pregnant women?
Yeah, a senior level UPS employee even testified that the only employees UPS did not accommodate were pregnant women.
Wow, that's pretty unbelievable. What law did Peggy Young sue under?
So again, it was Title VII of the Civil Rights Act of 1964 as amended by the 1978 Pregnancy Discrimination Act. The Pregnancy Discrimination Act states that women affected by pregnancy and childbirth, quote, shall be treated the same for all employment-related purposes as other persons not so affected but similar in their ability or inability to work.
So we were talking about victories. What was the vote in the United States Supreme Court?
Well, it was actually essentially a 6-3 decision. Justice Breyer wrote the majority opinion, and that was actually signed by Chief Justice Roberts and the 3 female justices, of course, Justice Ginsburg, Justice Sotomayor, and Justice Kagan. Justice Alito wrote a concurring opinion, so he essentially agreed with the majority for the most part.
And what did the majority decision say?
The majority held that Peggy Young needed only to show that UPS had accommodated others who were similar in their ability or inability to work. In other words, UPS could not claim that pregnant women were necessarily different than other workers who needed accommodations.
Gosh, that sounds pretty straightforward. Who dissented, and what were their reasoning?
The late Justice Scalia wrote a dissent that was signed by Justice Thomas and Justice Kennedy.
Ooh, a Scalia dissent. I don't typically agree with him, but his dissents were always entertaining.
This was the classic Justice Scalia dissent. He accused the majority of crafting, quote, a new law that is splendidly unconnected with the text and even the legislative history of the Pregnancy Discrimination Act. Justice Scalia also claimed that the majority reached its, quote, desired result by, quote, a couple of waves of the supreme wand. He even emphasized his magic wand metaphor by saying, poof.
Justice Scalia. Well, I'm glad the Supreme Court finally handed a victory to women in the equal pay arena.
Yep, that was great. And there's actually also been some great equal pay progress right here in California. So Ashley, didn't California just pass its own equal pay law this year?
Yes, California's equal pay law went into effect this January.
Who introduced the new law?
State Senator Hannah-Beth Jackson from Santa Barbara and Ventura counties.
Can you tell us a little bit more about State Senator Jackson?
Absolutely. She's a lawyer, just like the two of us. She started in state government in 1998. She received all sorts of awards and accolades, but what's really interesting is that one of her inspirations for pushing this law came from watching the Academy Awards.
You mean the Oscars?
I do mean the Oscars. Yes. In 2015, Patricia Arquette won the Oscar for Best Supporting Actress. As part of her acceptance speech, she advocated for equal pay for women.
Ooh, let's hear the speech.
Let's hear it.
Each of the nominees for Best Actress in a Supporting Role is proven and powerful. They are 4 women, plus in accordance with California state law, Meryl Streep. Thank you. I was a little nervous about that one.
Ecological sanitation to the developing world with GiveLove.org. To every woman who gave birth, to every taxpayer and citizen of this nation, we have fought for everybody else's equal rights. It's our time to have wage equality once and for all, and equal rights for women in the United States of America.
That was J-Lo in there. So we can thank an actress and a female state senator for our new equal pay law here in California. What does the California equal pay law say?
California actually passed an equal pay law in 1949, but it had some loopholes. For instance, the old law required wages to be compared at the same establishment, but that meant that a woman working at a company's Santa Cruz location could not be compared to the man working in the same exact position at a company's San Jose location.
So did the new law get rid of that same establishment requirement?
It did. The new law also ensures that employees performing substantially equivalent work are paid fairly by requiring equal pay for substantially similar work, no matter where it is performed.
What else will the California equal pay law do?
Well, the old law did not protect employees from retaliation for asking about wages of other employees. The new law protects an employee from retaliation for trying to get that information, which is absolutely critical to a female employee exercising her right to be paid for equal work.
Awesome. It sounds like women will be getting more information so we can keep up the fight for equal pay. So what about all the proposals to raise the minimum wage at the state and federal level? Will that help women get closer to equal pay?
Possibly. There's some data that suggests that a higher minimum wage would help women in the traditionally low-paying jobs. So, though waging those wages would eliminate some of the pay disparity.
All right. We've got the California equal pay law. Maybe we'll raise the minimum wage. Well, how about if we finally passed the Equal Rights Amendment, the ERA?
That would be huge. Here is what the ERA would say. There's definitely a good argument to be made that the ERA would help in the fight for equal pay. Most people believe that if an ERA is passed, sex discrimination would get the highest level of judicial scrutiny, just as race discrimination does, instead of the intermediate scrutiny that it currently gets today.
Where are we on passage of the ERA?
Suffragette leader Alice Paul introduced the ERA in 1923 as the next step in bringing equal justice under the law to all citizens. It took until 1972 for the ERA to finally be passed by Congress and sent to the states for ratification. The states then had 7 years to ratify it. Even after an extension of deadline, the ERA had been ratified by only 35 states, 3 short of the 38 it needed to put it on the Constitution.
What states ratified the ERA and which ones didn't?
Can you guess? Here's a map. Even some of our neighbors, look at that.
Are there still efforts underway to pass the ERA?
Yes, it's actually been reintroduced every year, and so maybe someday. Wouldn't it be great if our daughters could see that the Constitution actually guarantees their equal rights?
I would love for our daughters to see that the Constitution guarantees their equal rights. So what else can we do? Can we elect and appoint more women and, more men that are committed to equal pay?
I think that would certainly help. As we've seen, women have been the driving force behind all of the legislative efforts and key members of the courts in cases advancing equal pay. We need more women like Barbara McCluskey, Hannah Beth Jackson, and Ruth Bader Ginsburg, and more men committed to equal pay too, like President Obama.
And you mentioned something about information earlier. What about information gathering as a tool? Or, all these charts and data seem really important to showing that women are still not getting equal pay, and why?
And that's very true. President Obama is even making efforts to get companies to disclose pay data for this very reason. Mandatory wage disclosure laws may be part of the solution to the wage gap. By providing women with the necessary information to bring a claim, more discrimination can be uncovered and hopefully addressed.
Don't we kind of have a big wage gap problem here in the Bay Area in the tech industry?
Yep. In 2015, a study found that in Silicon Valley, men with university degrees are earning much, much more than women. Men with bachelor's degrees made 61% more than women with the same degree.
Wow. And I think there was a lot of media coverage recently of a gender pay lawsuit by a woman in the tech industry here in the Bay Area.
Yes, the Ellen Powell case. Ellen Powell had worked for a venture capital firm called Kleiner, Perkins, Caulfield, and Bayer. Ellen had a pretty impressive background. She had a bachelor's degree in electrical engineering from Princeton University, a Juris Doctorate from Harvard Law School, and an MBA from Harvard Business School.
Wow, she was pretty accomplished. What was her lawsuit about?
After repeatedly being passed over for promotions while they were given to her male colleagues, Ellen Powell sued her employers, alleging gender discrimination.
So did Ellen Powell win that lawsuit?
She did not. It was a 24-day jury trial, and the jury found in the employer's favor. However, Powell and her case have been credited with focusing attention on the issue of gender discrimination and workplace sexism, especially in venture capitalism and technology industries, and for inspiring others to act. The impact of Powell in the case have actually been known as the Powell effect.
All right. And there's actually some tech companies around here that are doing much better with the wage gap, isn't that right?
That's right. There's been pressure from other venture capitalist firms for companies to release their information. And new reports from Apple, Amazon, and Intel show that they have been closing the pay gap, paying women over 99% of what men are paid for equal work.
That is great news. Very cool. And in other news, didn't the United States women's soccer team just file a really big equal pay lawsuit?
Yes, they did. Just recently, the women have won 3 World Cup titles, 4 Olympic gold medals. How many World Cup titles have the men won?
0.
And the men have won 1 gold medal 120 years ago. And the women's team generates way more money for U.S. soccer than the men's team does, but they're not paid the same.
Wow. Well, it sure is awesome that these famous women are demanding equal pay and getting so much media attention. But how about us just as individuals? What can we do in our own workplaces to make sure we're getting paid equally?
Well, we can take some responsibility. We can speak up and not accept that we are being paid less than men. We can remind ourselves and each other that we are just as valuable as men.
I think actress Jennifer Lawrence made that point recently.
Yes, Jennifer Lawrence had said that while she was generally aware of the pay gap between men and women, it took the Sony hack for her to realize that she was actually paid far less than her male counterparts for her hit movies. That made her realize that she herself was partly to blame. She didn't see it as something unfair being done to her. Instead, she realized that she had been fearful of being seen as unattractive for demanding equal pay during contract negotiations.
Wow, that's really interesting. I hope she demands millions for her next film.
Yes, I think we all need to be vigilant and stand up for ourselves and each other when we see it happening to our friends. We know we are worth as much as a man doing the same work.
That is a great point. And we have a few minutes, and we wanted to kind of open this up and let people in our wonderful audience tell us what you guys think. Have you been afraid to stand up for equal pay, or have you demanded equal pay and gotten it?
Bringing it back to the California Equal Pay Act, are there any caveats to a person, a woman, anybody's ability to get the salary information regarding their employees? Are there employee number limits? What are the caveats to that law?
No, I don't.
What enables a woman to ask their employer, hey, how do I rank?
I don't think that the law actually allows her to go repeat the question.
Yes, we've got an employment law
to get information from their employer, from each other about pay in the workplace. So employment information about pay is considered confidential from your employer. Nothing about this law creates an obligation on the part of employers to disclose that information affirmatively to their employees. However, what it does create is a cause of action for an employee who asks their colleagues for information and is retaliated against for having done so, regardless of whether or not your colleagues actually tell you. There were some existing protections for employees. If you discuss your wages, in California, there's a specific protection for discussion of wages, even if it's on company time. And then for employees who are covered by the National Labor Relations Act at a national level, you're also protected under Section 7 rights for discussing terms and conditions of employment and working conditions, which certainly would cover pay questions.
But the NLRB only applies to companies of a certain size.
No, the NLRB is, the threshold has to do with what level you are of an employee. So if you're a manager employee, you're not covered by it. But the Equal Pay Act in California, or the Fair Pay Act, does cover all employees in California.
My thought is that there should be a way for women to ascertain exactly what they're being paid in relationship to other employees, where they're not being identified personally, of course. But there's really no T.
And that's actually what President Obama has been pushing for in part. And then you have some of the venture capital firms around here that have been pushing for that information to be released as well. Like Wheelock Capital invests in many of the Silicon Valley companies. And one of the things that they went out and said to the companies that they own substantial shares in was, we want to see the pay breakdown. We want you to go in and audit yourself. And I don't know if you saw the news reports about Amazon saying that they were at 99%, and we mentioned that initially Amazon balked. They said, we're not going to give this to you. They even went to the FEC and asked that they be allowed to not give this up. And finally, I think they did an internal audit and found out that they weren't that bad and decided not to give it up. And especially on the heels of Apple and Intel, because Intel reported that they were basically at 100%, and Apple came out and reported that they were at 99.6%, and that they were working to close the last 0.4%.
And that's great. I mean, it's 3 companies
Right.
that are doing it.
Well, and this is why, I mean, the investors like Wheelock Capital going out to try to push the companies for more information. I mean, granted, they own 2 or 3 or 15% of these companies, so they have the ability to push for that, but even smaller shareholders can be pushing, can be showing up at shareholder meetings, can say we want this information. And I think that's something that we all can be doing to push for it. Yes?
Do you know, is there less of a pay difference in union environments? Any information on that? I don't guess it there is.
You got another expert? I don't know the answer.
The question on hand is if there's a difference between union environments and non-union environments. And Bob Lewis.
All I can speak for is my own experience, of course. But I worked for AT&T for 29 years. It started with the IBEW, International Brotherhood of Electrical Workers, and then I went into the CWA, Communications Workers of America. There was zero discrimination. Why? Because the union actually set the salary grades, and it was based on time and service, and that was it.
So that might actually lead to another problem. It might not be the pay grades, but it might be the ability to get into management, to get the upper level salaries that might be a problem. And that's probably where the discrimination would have occurred then. So the women might have been left at the lower level positions, even though they were getting the highest pay at those positions and not being discriminated against in pay.
I have to say something that's kind of amusing. My mother was a real trailblazer. When she went to Hastings in 1963, women comprised 8% of the law school.
You know, there are over 50 at most law schools now.
And when she got her degree, and she was hired by East Water as their big headline, the first woman attorney, you know. And then the picture in the paper was she and my aunt holding a pie. Not really much of a cook at all. But the subheading said, you know, baking the topic when this family gets together. And so it was funny because even though she was trailblazing, even though she'd been hired the first, still the world at large didn't know that she could bake.
Yes, Bob?
Has there been any studies of companies where the women are the CEOs of less than hired Yahoo and so forth, and how that relates?
Is there a trickle-down effect? The question is, for companies that are headed by women, is there kind of a trickle-down effect where there's greater equal pay in those companies?
And actually, I don't have any research on that specifically, but there is some evidence to support that where women have made it further up the ladder, that pay starts to become more equal. There's been other companies, and this is not one that's led by a woman, but like, for instance, Salesforce.com, another Silicon Valley firm, audited itself, and this, I don't know what pressure brought it to do this, and it found that it had 6,000 employees out of whack and adjusted 6,000 employee salaries. So I think one of the things we do need to see is more women towards the top, because there is a disparity of women in the Fortune 500 companies and in Silicon Valley on boards and in the top positions. And I think that would certainly help pay. It couldn't hurt it.
I think from the opposite direction, getting younger girls even like aware of this problem is could be a big factor. Like I think you tend to adopt the rights movements of whatever you're living through at kind of a younger age. So like my generation is really tuned into police brutality and kind of race relations, but gender equality has not really been on my radar, because I haven't lived through a lot of these big movements that you talked about. And so I think going forward, it's going to be really important to teach younger girls growing up that this is still an issue and something that they need to care about, because unless the media continues to give attention to like a FIFA or the women's soccer scandal, then children who are kind of coming up now aren't necessarily even going to consider this an issue, even though it still is there.
It's a great point, and it's actually been so wonderful today for there to be so much media attention still on Equal Pay Day, and I think you couldn't really go anywhere or look at a newspaper or turn on the TV or the radio without knowing it's Equal Pay Day. And I think we can appreciate that the media is continuing to bring the issue to the forefront, so that our kids that are on Instagram and Facebook are seeing videos about the women's soccer team and are becoming aware of it. I also just want to say I showed our slideshow to my 12-year-old daughter, and she saw that airline pilot at the top of the list, and it was only 4% women. She said, "That's what I want to be."
Speaking of media attention, two things. One is that today President Obama went to Alice Paul's house, and actually there was an opening of a museum sort of a thing there for equal pay. But then right after that story, National Public Radio, all things considered, had a Harvard professor, woman, come on and tell us that she had just finished a study and wrote a book, I believe, that said that they've studied all this, and in fact, the main reason why women don't get equal pay is because they want more temporal flexibility in their jobs. And then she went ahead to explain that means, they want to have time off for kids and for this and for that, and they want to have more flexibility in their schedules. So it's still there very much, and you may want to investigate that and send some feedback.
Yeah, I think that's a problem that we face in our everyday lives of rearing children. And what has to happen is that, and it is happening more and more, that men pick up more of that burden so that they feel the same need for that flexibility. And if men want it as much as women do, and I think that they do, they don't want to be at the office for 14 hours a day either. They'd like to see their kids sometimes too. Once they start fighting for that, then hopefully that will help as well. I mean, that's just a personal thought, but I think
I strongly agree. I mean, it shouldn't be the burden's on the women to do the child care so that we can't advance. And that's not just our own problem, that's the whole society-wide problem.
Any other thoughts, comments, questions?
I was thinking as you were going through all the different cases, and like every time there was a case, it brought up a loophole, and we'd get shot down by this loophole. Well, we'd write a law to cover the loophole, and then the next case would highlight the next loophole. Any thoughts as to whether we're catching up on the loopholes, if we're ever going to get to the point where we can successfully, make some progress?
It's Congress's job to write out those loopholes and lawyers' jobs to find them, right?
And this is why this battle over the Supreme Court is raging as, crazy as it is, because, some of these decisions end up being 5-4 decisions. And, one very esteemed justice sees it one way and sees this loophole, and the other wants to shut it down. And this is why, this issue is just so humongous right now that we have an opportunity to fill that seat with somebody who can, hopefully rule out some of those loopholes that are prohibiting women from full equality.
And even when the law looks pretty clear, another justice might decide that, no, you're missing the loophole that clearly lets them off the hook for this. So,
Exactly.
there's definitely going to be some interpretation in the laws. Unfortunately, I sit with a lot of clients and like, the law is kind of gray. They want the answer, but you can't give it to them because that's not the easy, you don't always have it until you get to the Supreme Court.
I want to thank you for a terrific presentation, and it was really great to get the point of view of two lawyers, two practicing attorneys, because the way that you showed the laws made it very clear. And the fight ahead, I'm receiving lobbying alerts on different measures, and I think it's important for all of us to respond to those when there's an equality pay issue, and to send our emails or write our letters if you will. Yeah, that's one of the things we can do.
That's right, we're all voters. Well, actually, perhaps in our lifetimes, we will see equal pay for women become a reality.
Well, we both have daughters, as has been mentioned before, and I am confident that with more legislative action, more women speaking up for equal pay like Lilly Ledbetter, we're going to get there someday.
Thank you all so much.
Thank you.